So, good evening. Good evening, everyone. My name is Kevin Walton, and I'm the director of the Julius Stone Institute of Jurisprudence. On behalf of the Institute, I'm pleased to welcome you to this year's Julius Stone address. I would like to start by acknowledging that this evening's lecture is taking place on the land of the Gadigal of the Eora Nation. The law school is built on their ancestral lands, and I pay my respects to their elders past, present, and emerging. I also wish to acknowledge the financial support of the Educational Heritage Foundation. The Institute thanks the Foundation for its generous funding of the Julius Stone Address. The Julius Stone Institute of Jurisprudence, which was established in 1999, seeks to contribute to scholarship in legal theory, broadly understood, that is, as Julius Stone understood it, at the University of Sydney and beyond. The Institute organises regular seminars and occasional conferences. Indeed, this evening's lecture is part of a conference on the theme of responding to injustice that's been taking place today and will continue tomorrow. The Institute also supports research in legal theory through the Rika Stone PhD scholarship, and in 2023, through a postdoctoral fellowship, and a visiting professorial fellowship. In addition, every 5 years, it awards the Dennis Leslie Maney Prize in Legal Theory, which is worth $50,000. None of these activities would be possible without the generous support of Dennis Maney and other friends and family of Julius Stone. The Institute's grateful to them all. Let's turn then to this evening's event. I'm delighted that this year's address will be delivered by Professor David Deisenhouse of the University of Toronto. Professor Deisenhouse is one of the leading philosophers of law in the world today. He's made significant contributions to the field in his many publications, including in his books, Hard Cases in Wicked Legal Systems, South African Law and the Perspective of Legal Philosophy, which was first published in 1991 and is now in its second edition. Legality and Legitimacy, Carl Schmitt, Hans Kelsen, and Hermann Heller in Weimar, which was published in 1997. Judging the Judges, Judging Ourselves, Truth, Reconciliation, and the Apartheid Legal Order, which was published in 1998. The Constitution of Law, Legality in a Time of Emergency, which was published in 2006. And most recently, The Long Arc of Legality, Hobbes, Kelsen, Hart, which was published this year, and which, incidentally, was recently discussed by the Julius Stone Institute Reading Group. In recognition of his scholarship, Professor Deisenhouse has been appointed a Fellow of the Royal Society of Canada and a corresponding Fellow of the British Academy. He's also held numerous visiting appointments at universities around the world. The title of Professor Deisenhouse's lecture is The Legal Experience of Injustice. David.
Well, thank you very much. It's a great honor to be asked to give the Julius Stone address. I'm not going to be talking about Julius Stone tonight, but I thought I would say a few words about him at the beginning, as people will know better than I do here, although I actually have been reading him for many years. Julius Stone was a polymath, but what I appreciate most about him was, first of all, the blend of social, legal, and political theory in his work. Secondly, his attention to figures outside of the Anglo-analytic tradition. And thirdly, in this he was way ahead of his time, his view that international law is part of an inquiry into general philosophy of law. Thank you very much, Kevin, all the others who've made it possible for me to be here. I love being in the Antipodes, and of course, in this part of the Antipodes, Australia. And plus, some of my favorite people in the world live in this part of the world, and some of them are actually present in the audience tonight. So it's a great pleasure for me to be here. I didn't know Julius Stone. I heard earlier today from the Dean of the Law School that he could be somewhat irascible. And if you look at him over there, he does look somewhat irascible. But as it happened, I was apologizing to one of my colleagues, a very eminent philosopher of law, Ernie Weinrib, for not being at an event that was being held in Toronto today. And I told him I was giving the Julius Stone address, and he said this to me in an email, which I thought I would repeat to you with his permission. Ernie said, he's now retired, that when he was a very junior academic, he heard that Stone was traveling in North America, and he got him to come to the University of Toronto to give a talk. And Ernie says he doesn't really remember what the topic of the talk was, but he says, what sticks in my mind still is that he was an intelligent, thoughtful, kind, and gracious gentleman who treated me and my no doubt unsophisticated views with complete respect and interest. He seemed to me to be the very model of an academic jurist at a time when I was finding it difficult to find such models. So that's the personal recollection of Julius Stone. Now, as Kevin mentioned, the lecture is part of Julius Stone Institute workshop responding to injustice. And when Kevin sent out their invitation for this workshop, one of the quotations that he offered us was from the famous political theorist Judith Sklar and her book, The Faces of Injustice. And the insight in one of those quotations is the insight that now appears on the screen, that the real realm of injustice does not stand outside of the gates of even the best of known states. Most injustices occur continuously within the framework of an established polity with an operative system of law in normal times. And I used this quotation to go back to reading Julius Sklar and trying to read her systematically for the first time ever. And I found this a wonderfully enriching process. My paper, as you know, is titled The Legal Experience of Injustice. And what I try to draw out in this paper is what is special about the experience of injustice when it's perpetrated by law. And I found Sklar's insight to be just right in this respect, because what she draws our attention to in offering us this insight is that while we often tend, when thinking about injustice, to think about injustice in places where the examples of injustice are dramatic, and I'll be talking about some such examples tonight, it is the case that when we do look at these other places, we should look at them in order to be more alert to the injustices that are endemic in our own states, no matter how well run, and indeed inevitable. So that's where I start. Sklar offers a second insight, which wasn't among the ones that you sent out, Kevin, in the same set of thoughts from which the first is drawn. And I call this the Hobbesian insight, even though she doesn't herself call it the Hobbesian insight, because in my view, you could lift this insight directly from the pages of chapter 13 of Hobbes's Leviathan on the state of nature. And the second Hobbesian insight is that without juridical institutions and the beliefs that support them, there can be no decent, just, or stable social relations, but only anxiety, mutual mistrust, and insecurity. And what I want to do in my talk tonight is to connect the second insight to something that Hobbes himself said in order to perhaps show the relationship between the first insight of Sklar's and the one that's on the screen now. So now we can turn to my favorite political philosopher, Thomas Hobbes. Duncan Iverson said earlier that whenever he meets me, I'm talking about Thomas Hobbes and the rule of law, and it's true, it's going to happen again tonight, Duncan. Hobbes in Leviathan, talking about law, says that law is the artificial chains that the sovereign subjects have fastened at one end to the lips of the man or assembly to whom they have given the sovereign power, and at the other end to their own ears. These chains, he says, are in their own nature but weak, but may be made to hold by the danger, though not by the difficulty of breaking them. Hobbes, right at the end of Leviathan, in the very last couple of paragraphs, says that the whole design of the book is to set before men's eyes the mutual relation between protection and obedience. I was giving a talk on Hobbes on sovereignty to a group of historians a few months back, and one of them pointed out to me that this image of Hobbes, of the law as a chain which subjects fasten to the lips of the sovereign, is based on something he thought which is called the Gallic Hercules. And there you have the image of the Gallic Hercules, a rather awful image, this giant with a club dragging the subjects after him with a chain. And one might think that there's something deeply disturbing about this metaphor of law as chain in Hobbes, especially the idea that it's the subjects themselves who fasten the chain from their ears to the lips of the sovereign, and that somehow the last lines of Leviathan, this creates a duty to obey the law, because insofar as the sovereign offers protection, so people are obliged to obey. So this might seem like a very authoritarian picture of law, because it's the subjects who constitute the authority of the sovereign. But I think what Hobbes is after is very much an attempt to try to understand law as both a matter of might and right, with the emphasis on the right. And now we can jump forward a few centuries to the great English legal philosopher, H.L.A. Hart. As those of you who know Hart's work, particularly his 1958 piece in the Harvard Law Review, Law and the Separation of Law and Morals, will know that Hart in that essay seeks to move philosophy of law away from what he thinks of as the command model of law that was put forward by his predecessors, Bentham and Austin. And Hart says that we shouldn't understand law as just a matter of commands backed by might. So there we have a very simple picture of the command model of law, with the sovereign who's legally unbound, issuing commands, and then we have those who enforce the law. Subjects obey the law because they fear the sanctions that will attend non-compliance. Hart thinks that what's fundamentally mistaken about the command model of law is it doesn't capture law as it works in the register of authority. This is not a denial of the coercive dimension of law, but just trying to call our attention to the fact that law also operates in this dimension of authority and right. And in making the choice to understand law as a matter of authority, I think something interesting happens, and I'll talk about this a bit later, because I think this choice, the theoretical choice to understand law as a matter of authority, connects to the choice that people make when they choose to participate within a legal order. And my focus is going to be here on the choice that human rights lawyers make when they choose to practice human rights law within an oppressive or unjust order. Hart's main idea, as he expressed it in 1958 and then elaborated it in 1961 in the concept of law, is that we can't understand law as a matter of commands backed by force, because law operates in the register of authority. We have to know what's law and what's not. In order to know what's law and what's not, in order to be able to recognize what counts as law, we need what he calls a rule of recognition. There are going to be fundamental rules in any legal society that condition the making of law. And when I try to convey this idea to my undergraduate students, I use this image of a notice board in the town square. The sovereign has to write the commands on the notice board in order that the subjects can know what counts as law and what doesn't. So what we have here is a very simple image of the move away from the command theory of law. Again, as people will know, a critique of Hart's position was put in place by Lon Fuller, the American legal theorist. And Fuller's critique can be summed up, I think, as follows: that it's not enough for laws to be made public, to be put on the notice board, for law to do its job of governing the lives of those who are subject to law. There are other principles that law has to comply with besides the principle of publicity. And for Fuller, these were generality, non-retroactivity, clarity, non-contradiction, possibility of compliance, constancy through time, and congruence between official action and declared rule. And so much is, I think, pretty well taken for granted in legal theory. You can't have too many contradictory laws. You can't have too much retroactivity. There has to be constancy through time. People have to be able to understand the law, and so on. So that, as I've said, is more or less the common ground in philosophy of law when it comes to legality or the rule of law. What's controversial is that Fuller made further claims about what's put in place if you have these principles of legality operating. And he said that what one would get is what he called an inner morality of law. There would be some kind of moral quality to the law. That amounts in Fuller, as I interpret Fuller, to what he called a bond of reciprocity between subjects and ruler. And he claimed further that every departure from the principles of law's inner morality is an affront to man's dignity as a responsible agent. So it's this moral overlay that Fuller seeks to put on his principles of legality that I think is the sole site of controversy when it comes to these issues in philosophy of law. And here now comes my attempt, ably assisted by someone who makes these images for me, to depict the debate in philosophy of law in just two images. And what we have on this side of the screen is what I call the rule of law state, as Hart and legal positivists tend to understand the rule of law state. So we have the sovereign, who's really the ultimate legal authority, enacting law that complies with formal principles. We have various officials, the judges and enforcers. We have the subjects. The subjects, in order to know that what's being applied to them is the law, Fuller's principle of congruence, that what the officials are doing is congruent with the laws as they appear on the notice board, must comply with a further set of principles, which we call procedural principles. That is, you can contest an official's understanding of the law. You should be able to contest that understanding before an official who's independent of the one who did whatever was done to you. That official must be impartial, and so on. I think Hart accepts all of that as part of his picture of what I call the rule of law state. And then the only difference between Hart and Fuller, or if you like, between legal positivists and certain kinds of natural law, is the one element that is present in the rule of law state 2, Fuller, and that's the bond of reciprocity, which is very much like Hobbes's artificial chain of the law, what binds the sovereign to the subjects. Fuller's view is that if you put in place rule of law state 1, you'll also get the bond of reciprocity. There's a moral quality to that bond, and that's precisely what Hart and other legal positivists deny. And what I want to argue to you tonight is that as long as one maintains rule of law state 1, including the legal framework around the whole of the space in which these various elements occur, there will be something like a bond of reciprocity. If that bond is put under any kind of strain, tensions will arise within the space, and the tensions might get to the pitch when actually elements within the space will start to either disintegrate or even to disappear altogether, so one will no longer have a rule of law state. So in order to maintain a rule of law state, you need to keep everything that's in rule of law state 1 in place. That will establish the bond of reciprocity. If the bond of reciprocity is undermined, so will the elements in rule of law state 1. So I want to say a little bit about the positivist critique of Fuller. And what I'm going to say now actually changes somewhat from the text in my paper, because in the paper which was circulated to people in the workshop, I claim that Sklar's critique of Fuller is very much of a piece with a positivist critique of Fuller. I came to realize in putting together this lecture that actually Sklar's critique is interestingly different. So let me start with Sklar's critique. Sklar said of Fuller that his inner morality is perfectly compatible with governments of a most repressive and irrational sort, since the very formal rationality of a civil law system can legitimize a persecutive war state among those officials who are charged with maintaining the private law and its clients. And she said this was certainly the case in Nazi Germany, whose legal caste were perfectly ready to ignore the activities of the new court, police, and extermination system, as long as the inner morality of their law could remain unaffected. And when I first read what Sklar had to say about Fuller in this regard, I thought it was of a piece with the general positivist critique of Fuller. This positivist critique is most famously made in an essay by the legal positivist, Hart's most influential student, Joseph Raz, called The Rule of Law and Its Virtue. And Raz, in his critique of Fuller, says that what the rule of law does, compliance with rule of law principles, is to make law into a more virtuous instrument of a certain sort. And he analogizes this to a knife. He says, what is the specific virtue of knives? The specific virtue of a knife is sharpness. But you can do all sorts of good things with a knife, and you can also do all sorts of bad things. So you shouldn't think that there's any moral quality to a virtuous knife. And the same, he thinks, applies to the law. This virtue of the rule of law is that it makes law into a better instrument for implementing policy, but everything depends on the content of the policy. I think this is quite different from Sklar's critique, which is not about the rule of law being a better instrument, but about being compatible with evil alongside it. And that's what I'm going to be focusing on in the next while. But I do want to make just a quick point about the positivist critique, which is a point that I think I largely owe to my acquaintance with Crystal Rundle's work on Raz and on Fuller. It struck me that the choice of a knife as the analogy that Raz uses in this famous essay rather rigs the argument. Imagine a virtuous spanner, right? A virtuous spanner is a spanner that can do certain jobs, but it'd be very hard to do something really bad with a spanner. And I think that the law is a kind of instrument, but what is the kind of instrument it is? It's an instrument for trying successfully to govern the interaction of legal subjects with each other and with the state. So to analogize it to a knife is, I think, already to get off on the wrong foot. But that's just a side note about legal positivism. Right, to continue with Sklar. Sklar cited in support of her claim the German lawyer and political scientist Ernst Frankel's The Dual State as one of the few older studies of the Third Reich that remains valid. She also suggested that the paradox of slavery that made the slave both a human person and a property of another created a dual state in pre-Civil War America as well, and it was just as irrational. So there we get the conjunction of the claim that you can have the rule of law side by side with irrationality, and this shows that Fuller's argument that if you have rule of law state in place, there'll be some kind of moral quality to law. That shows that that argument is wrong. I'm now going to move to my focus on human rights law as an attempt to find a way out of these problems. And here you have my human rights lawyer, Michael Sward, a human rights lawyer who works in the occupied territories of Israel. And you have an image of his book, The Wall and the Gate, Israel, Palestine, and the Legal Battle for Human Rights. And what I want to bring to your attention is three claims that that Sward makes in the last chapter of his book. The one is he points to what he thinks of as the paradox of human rights lawyering, that human rights lawyers have to struggle with the fact that winning lots of legal victories may not only not affect the bad regime that leads to the policy, but even serve to legitimize it. And I think this is a very interesting point. Yesterday, when I met with Wojciech Szyderski, he told me that he had just won another of his legal victories in his battles with the Polish state. And he said to me, well, and this was said ironically, well, this might serve to show that really the Polish state is a decent rule of law state. After all, I would keep winning in court. And this is a problem, right? So human rights lawyers know that, both when they lose and when they win, because they're participating in this game of legality, which somehow attracts some kind of legitimacy, this will serve to legitimize the very policy that they take themselves to be struggling against, and which they know they can't actually change through their human rights work. Why does this happen according to Svard? Here we get the second claim about legal norms. He says a legal norm does not just dictate, it also justifies. For the most part, we obey statute and case law, not just because they come with mechanisms for enforcement, but because we accept that following them is the right thing to do. We accept for the most part that a norm established through the prevailing constitutional order is justified. A legal norm is at one at the same time and is and an ought. It both binds and educates. Now, in making this claim, Svard might seem to set himself against legal positivism, because legal positivism, at least as I understand it, hews to the separation thesis that there's no necessary connection between law and morality. That's why you can have rule of law state in place, but still have a highly immoral situation. But Svard claims that he can sidestep this debate. He says there's a fervent debate between legal positivists and other schools of philosophy of law over the nature and characteristics of a legal norm, but he says he can sidestep this debate and still make the claims that he makes about a legal norm. There is a sense, I think, in which Svard is right, that he can sidestep this debate. Remember that Hart introduces the idea into philosophy of law, that law has to be understood as a matter of authority and as well as of right. But for Hart, this idea of authority is not an idea of legitimate authority. Law just has authority. It operates in the register of right. Officials have to accept that following the law, implementing the law, and so on is the right thing to do. But one shouldn't confuse that sense of right with a sense of moral right. It might be that in order to play the law game, if you're going to be, say, a human rights lawyer, you have to pretend that this is a system of rightful authority, but that doesn't make it a system of rightful authority. And Svard himself has said to me, because I've just asked him this question, that he understood the idea of authority more in, let's call it the Harshan sense, than in the Fullerian sense. That is, there's a system of norms there, the norms justify, but they don't justify in a way that one should suppose involves some necessary moral component. I'm going to suggest to you that there is a moral basis for human rights lawyering in any legal order, as long as it is a legal order. And my key here is the work which we saw that Sklar cited in support of her claim against Fuller, and that is the work by Frankl, which he called the dual state. Frankl, in his analysis of the Nazi state, described it as a dual state, and the dual state consisted, as he understood it, of two states side by side. On the one side, there was the normative state, which was whatever remained of the law and institutions of the Weimar legal order, plus the ordinary law, by which I mean just the statutes of the Nazi regime. And then next to that was the prerogative state, which consisted of the apparatus of the Nazi party, wherein the leader's will was the ultimate source of authority. So there we have the image of the dual state. And if you can think back to either of rule of law state or rule of law one, there is a big difference between the dual state and rule of law state. Well, there are probably two big differences. The one is one doesn't have a solid line around the spaces. One has a porous line, including a porous line in between normative state and prerogative state. And what's more, the sovereign is firmly located in the prerogative space. And what that tells one is that in Nazi Germany, while law could be left to run its, let's call it normal course within the normative state, so you have a contractual dispute with someone, you could take that dispute to a judge, the judge decides the matter in a fair and impartial way. If an official in the prerogative state took an interest in this matter because he thought that the Nazi party should be concerned with this matter, that matter could be extracted from the normative state into the prerogative state and dealt with at the whim of the prerogative state official. Moreover, if officials within the normative state, in order to prevent this kind of yanking of matters from the normative state into the prerogative state, started to decide matters more and more in the prerogative manner, anticipating the way that officials in the prerogative state would have decided the issue, in order to keep the matter within their jurisdiction. And so the normative state was hollowed out from within. And Frankl concluded, as a result, that there was no rule of law in Nazi Germany because the law of the normative state governed only as long as officials in the prerogative state did not find such government inconvenient. Here we have an image of the memorial plaque outside of Frankl's house in Berlin, which tells you that in this house, Frankl lived until his immigration in the US to the US in 1938. Frankl practiced law in Nazi Germany in Berlin from 1933 to 1938, something which seems quite astounding because he was not only Jewish but a socialist, but he had an exemption from the law in 1933, which kicked Jews out of the profession because he had served in the First World War. In a preface to one of the German editions of his book, The Dual State, he says, as you can see there, in the final phase of my legal practice, I frequently describe my work to friends as that of a switchman, that is a railway switchman who switches trains from track to track. That is, I regarded it as an essential part of my efforts to ensure that a given case was dealt with under the auspices of the normative state and not end up in the prerogative state. Colleagues with whom I was on friendly terms confirmed that they too had repeatedly worked towards making sure that their clients were punished in a court of law. But what Frankl was trying to do was to keep things on the normative state track, but there was no guarantee that he could do so. And he gave up his legal practice, not least because he saw no point to practicing as a lawyer anymore in Berlin. And I think that if we're going to move to the level of theory, we can say that one couldn't be a human rights lawyer in Nazi Germany because one couldn't be a lawyer. People did not have any legal rights in Nazi Germany because what rights they had were entirely precarious, contingent on decisions of officials in the prerogative space. And this, I think, really can help us move forward in the debates in philosophy of law. Because what it tells us on my account is that if we place different rule of law states on a continuum of legality, we can see that the dual state, the state that Frankl described, is off the continuum. It just doesn't count as a rule of law state. There was no legal order in the Nazi state. There was an appearance of legal order in the normative state, but it wasn't an authentic legal order. So at the end where the dual state falls off, we have the far end of the continuum. The continuum starts with rule of law state, and then I'm going to talk about various other states which one can place on the continuum, the apartheid state, the parallel state, and a state which I say a fair bit about in the paper, but I won't be able to say much about it tonight, the pre-Civil War US. So let me move to that. So this is not just a plug for one of the books that Kevin mentioned, but it is actually a picture of an apartheid law, which is why I put it on the cover of the second edition of my book, Hard Cases in Wicked Legal Systems. And it depicts something fairly awful, but it's a wonderful illustration of an apartheid law, because there we have a little black kid trying to climb up a sign. If you know South Africa, you'll know that's an obviously white suburb behind, and the sign says whites only, reserved in terms of Act 49 of 1953. The same is said on the other side in Afrikaans. And this is the Group Areas Act. The Group Areas Act was put in place in the 1950s in South Africa in furtherance of the policy of apartheid. It allowed officials to reserve certain areas for residents by one racial group, and it was a crime for members of another racial group to reside in that area. And of course, these areas were set aside in a very particular way. That is, the best areas were set aside for white South Africans, and the miserable areas were given to the majority Black population. There was something interesting, I think, about the legal state in which this discriminatory law was enacted, and many other discriminatory laws besides. That is, it is, I think, a perverse version of a rule of law state, because we still have the general legal framework around the space. We have the ultimate legal authority, or the sovereign, making laws in just the fashion that one finds in the rule of law state. We have general norms that apply to all legal subjects. And then we have discriminatory laws that discriminate against the majority Black population. And what emerges within that space is the category of what I call the second-class citizen. That is the majority Black population. Because second-class citizens are individuals who are subject to the discriminatory laws, but at the same time, they're subject to the general norms of the legal order that apply to all individuals within that space. That made human rights lawyering possible, because human rights lawyers were able to go to court. There was no written constitution, so all the action was in administrative law, but to challenge the way that an official was implementing a law, for example, the Group Areas Act, by saying that while this law gave what seemed like blanket authority to officials to carve up South Africa into separate residential areas, it did not allow them to do that unreasonably or in a way that discriminated against one group as compared to another. And it was this kind of tension within the South African legal order that made it possible for human rights lawyering to occur even during the worst days of apartheid. And it could occur, I think, because the South African government, however problematic it was in many respects, wanted to maintain the rule of law, perhaps just for the sake of international legitimacy. So it kept that general legal framework around the space of politics. Matters are also complicated. I'll just say a little bit about this by what I call the prerogative space within this general legal framework, which was created by the security laws, which were put in place to stamp out political opposition. And these security laws became ever more draconian until the point where if you found yourself at the mercy of the security laws, you were pretty well put into a space where you could get no help from outside. You couldn't see a lawyer, you couldn't get independent medical attention, and you could be held for as long as the state deemed it necessary to hold you on the whim of an official in the security apparatus. But still, that prerogative space was within the general legal framework, and I can say this I can say more about this later if people are interested. That still did allow challenges to be made to the operation of the security laws. So there we have the apartheid state and an attempt at an explanation of how the fact that it was a rule of law state, albeit a perverse one, made it possible for human rights lawyering to take place. Now I'm going to get to Israel and the occupied territories. What is supposed to happen when after war, one country occupies another, you get the situation of belligerent occupation, which is supposed to be temporary. And you have two separate spaces, two separate legal spaces. And in the occupied country, those who are subject to law are governed by the local law that had applied to them before, as well as by international law. And the sovereign who remains in the occupying country is supposed to operate in terms of international law and local law for the period of the occupation. The way things that have worked in Israel and the occupied territories is not quite like that. What you get is what I call the parallel state. The two legal orders are united by the Israeli Supreme Court. So they're united at the top. There's still the legal framework around the whole space. And there's a porous line in between. And the Israeli Supreme Court regards the army as a branch of the state, hence governed by administrative law. So it will take challenges by Palestinians in the occupied territories to what the army is doing on the basis of administrative law. And the Supreme Court filters both constitutional law and international law through the prism of administrative law. So there will be, it will be possible, for example, to bring something like a claim that where the wall has been placed at one point or another is disproportionate in that the security demands of the Israeli army don't require that the wall be in that particular place, but everything gets filtered through administrative law. And so these norms govern the lives of Palestinians in a fairly watered down way. This situation is complicated by the fact that within the occupied territories, you have the settlements. And Israeli settlers are governed by Israeli law as if they were living in Israel. So you have these enclaves, which are kind of outposts of Israel within the occupied territories. And that, I think, turns the Palestinians in the occupied territories into virtual second-class citizens, in that they live side by side with settlers who are governed by the constitutional norms, directly governed by the constitutional norms of the Israeli legal order. And the Palestinians get those norms filtered through administrative law, which means that their interests weigh less in any conflict with the settlers. But even if there weren't these settlements in the occupied territories, the fact that there's one solid line around both spaces would mean that insofar as Israelis within the Israeli legal space are governed by constitutional law, the Palestinians would still be second-class citizens as compared to people in the space of Israeli law. And I think if one takes these two variants of the rule of law state, the apartheid state and the parallel state, one can see what happens when the bond of reciprocity between ruler and subject is disrupted in ways that discriminate against one group of subjects within the rule of law state. Either you create the category of second-class citizen, which creates tensions that human rights lawyers can exploit, or you can try to avoid creating this category of second-class citizen by putting in place a parallel state in which the subjects are governed by different systems of law, but that will create its own tensions as long as the two spaces are united in the way that we see the parallel state operating. You will still, much as you try to avoid creating the category of second-class citizens, you will end up creating something like that. And that will allow human rights lawyers to do some work in trying to vindicate the rights of those who appeal to them for help. Swart says in the last chapter of his book, there are great differences between apartheid South Africa and Israel's occupation. Ignoring the illegitimacy of decisions made by only one population in a regime that controls two is not among them. Even if he's right in making that claim, and I think he is, I don't think one should understand the idea of illegitimacy there as a claim that the whole setup is somehow illegitimate. There's also some authentic legitimacy in operation. And that comes from the fact that even though these two states, the parallel state and the apartheid state, may drift away from the ideal end of the rule of law continuum, the continuum of legality, they still are firmly on that continuum. And that means that to some extent, they will be legitimate just because they do operate in accordance with the rule of law. And that establishes some kind of bond of reciprocity between subject and ruler. And my thought here is that when human rights lawyers enter into the courtroom to represent their clients, what they're contesting is the nature of that bond between their clients and the state. And in choosing to participate in their legal practice in that way, they are affirming the authority of the state and affirming its legitimacy. I want to make the further claim, which may seem much more controversial, that to the extent that their clients permit themselves to be represented in this way, they are also participating in constituting the authority of the state and to some extent accepting that authority as legitimate. Of course, this is controversial, maybe even offensive to suggest that Black South Africans, when they had lawyers represent them in court, were affirming the authority of the apartheid state and in some sense even affirming its legitimacy. But I'm not sure that the claim is that controversial. And I'll just mention now that when some African National Congress soldiers were captured in South Africa, put on trial, they refused to be represented in court. They refused any legal representation because they thought that if they participated in their trials, they would be affirming the authority of the state and not only its authority in some neutral legal positive sense, but it's somehow legitimizing it, participating in the process that actually lends a legitimacy to the state. Swart himself, at one point in his chapter, seems to me to suggest something similar. He says that his clients start off as nobodies, weightless entities in space. The authorities ignore them, not even responding to their communications, batting them away like bothersome flies until they file a petition. As soon as the clients hire legal representation and enter the legal process, they gain heft and volume and visibility. And I think when he says that, what he's suggesting is that at that moment, when his clients enter the courtroom, gain heft and volume and visibility, what they become visible as is legal subjects. And what's in contest is what kind of bond that establishes between the state that claims authority over them and they themselves, who, at least for the moment, accept that authority in choosing, as it were, to play the legal game. And what we have here, I think, is the connection, which I suggested I would try to establish earlier, between the theoretical choice to understand law as a matter of authority and the choice of agents within the legal order to participate in that legal space in contesting the law as it applies to them, in seeking to vindicate their legal rights as they understand their legal rights to be. What we get, I think, is an understanding of authority as something relational, as something that's constituted by those who are subject to it, not only the officials, but also the lawyers and those whom the lawyer represent. So now we're back to rule of law state 1 and 2. And what I've tried to suggest to you over the last 45 minutes or so is, if we look at the dual state as off the continuum of legality and then inspect the other states that I talked about, rule of law state 1 and rule of law state 2, we can see that as long as rule of law state 1 is in place, we will have something like Fuller's bond of reciprocity, a relationship between sovereign and subject, as Hobbes put it, of protection and obedience. If that relationship is disrupted, if the artificial chain of the law is disrupted, then one of two things can happen. Either the state will change into an apartheid state, in which the category of second-class citizen will emerge, and that creates not only moral problems, but also legal tensions within the operation of law. Or one can try to shift one group of legal subjects into a somewhat separate legal space. So one tries to create a parallel state, but that also creates legal tensions with which human rights lawyers can work. The only way to get rid of those tensions is to create a dual state. But if one creates a dual state, then one no longer has the elements of rule of law state one. The rule of law is at an end, and legal order is at an end. In fact, people no longer have any legal rights. And so my concluding thought is that the legal experience of injustice, what happens when injustice is perpetrated by law, tells us something interesting about philosophy of law. It tells one that there's great agreement in philosophy of law, that law has to be understood as a matter of authority. The area of disagreement is only over whether that authority need be understood as legitimate authority. But if one pays attention to context and history, as Sklar urged us to do, we will see that when the rule of law state is in place, the authority that is established is, at least to some extent, legitimate authority. And that conclusion, I think, can take us forward in the old debate between legal positivists and natural law about the connection between law and morality. Thank you very much.
Thank you, David. That was fabulous. We've got some time for questions.
There's a question from the bit of the audience you were supposed to ignore.
David, thank you very much. That was terrific. My question is more practical than philosophical. In your written version, in your written paper, you allude, among other things, to a famous historical debate among legal scholars and legal practitioners in the late stages of apartheid in your home country. Yeah. And in particular, around the famous article by Raymond Wax, Should Judges Resign? And the response by John Dugard. So the former suggested, having elucidated all possible moral responses, that in a fundamentally unjust system such as apartheid, judges have no other moral option but to resign, while John Dugard had the opposite view, saying that they should try to rescue as much as possible of the possibly, I don't know, libertarian, liberating aspects of the system. The same debate about 50 years later or 40 years later is now being replicated in countries such as Poland and Hungary, where judges face similar dilemmas. From your point of view, and with the benefit of the hindsight, who was right, Dugard or Raymond Wax?
Well, I think the short answer is that Dugard was right. And why was he right? Because in part of that debate, Dugard suggested in response to Wax that one couldn't look at just the question of what judges could do at the time they were having the debate, but one also had to have an eye on the long term. And what was the long term? The long term was trying to preserve the rule of law. And why is it important to preserve the rule of law? It's important to preserve the rule of law because one hopes that at a certain point, the moral horror of apartheid will come to an end, a new political order will be put in place. And if one wants the rule of law to prevail in the new order, one better keep it alive during the time of the old order. And Swart, who in this chapter deals quite extensively with the Wax-Dugard debate, makes exactly the same point. Svard doesn't think that his practice of human rights lawyering is going to bring the occupation to an end. That's the first paragraph of the chapter. But he does think that human rights lawyering can, as he puts it, open cracks in the ideology of the regime. Why does it open cracks in the ideology of the regime? Because the reason that the parallel state is put in place, and I didn't mention this, is that the person in legal charge of things at the time, Shamgar, who eventually became a justice of the Israeli Supreme Court, wanted to ensure that the rule of law would govern in the occupied territories. And that's why the Israeli Supreme Court ends up uniting the two spaces at the top. And Svard says that it's very important to keep in place what he calls the culture of good government, because however things turn out in this part of the world, he thinks it's important that the rule of law should prevail. So I think Dugard is right for just that reason. I think there's also a second reason that Dugard was right, which had to do with the debate at the particular point in time that it happened. So Wax's understanding of the apartheid state was the apartheid state was a state in which the discriminatory laws had got to the point with the discriminatory laws that the ideology of the legal order was apartheid ideology. So the fundamental principles of the legal order were the principles of a racist ideology. And Dugard denied this at the time. He said, no, the fundamental principles of the South African legal order are not apartheid ideology, but the general norms, which he took to be the norms of what he called Roman Dutch common law, with presumptions of equality, liberty, reasonableness, and so on. And so I think that one can elevate his argument in a way that he didn't do at the time, but I think he implied it to a theoretical level, and that is to say that one couldn't have a legal state which had as its founding ideology and a thoroughly immoral set of principles. In order to have a legal order in place, one has to have something like the general norms that Dugard claimed were still operative at the time that he had the debate with Wax. So that's the way that debate figures into my argument.
Kristen.
David, thank you for the lecture, but also obviously for the decades of work and thought that's gone into being able to distill the way you have these thoughts tonight. I wanted to ask you a little bit more about the administrative law dimension of your Israeli occupied territories example. You might remember, and it's very similar to something that you were quoting from Svard, that Hannah Arendt in The Origins of Totalitarianism says something very, very similar about how in the period of internment camps of stateless people in the periods between World War I and World War II, if you were in that essentially prerogative state, the smartest thing you could do would be to commit a crime. Because if you committed a crime, you were pulled into a legal system that had processes, and you were, I mean, she makes an inflated claim, but it's fascinating, which is you almost become a respectable citizen by committing a crime, because you have to be treated by the juridical order as a legal subject. Whereas when you're in what we will call, in Frankel's terminology, the prerogative state, you don't have that status at all. So she was speaking to the political significance of the juridical order in terms of the status it would change for that person. But what is usually common when these contrasts are set up is that people are talking about law as a regime of rules that can be broken. Like her example is someone committing a crime, which is a breach of a rule. It's rather different when the condition of subjectivity that one is in is governed by discretion, because there's so much more room to maneuver on the prerogative side where discretion is involved. And that's why I just wanted to know a little bit more about the administrative law dimensions here, like what the promise and limitations of those are. Because although there might be legal principles of administrative law that we admin lawyers think of as in terms of judicial review principles that require certain things of governmental conduct held to a legal standard, when the conduct concerned is framed by politically inflated discretions, for example. There's only so much work that those legal principles can do. At least that's the experience I have in this country in terms of how much those legal principles can kick in around discretions that are designed to be heavily weighted towards political considerations, towards non-legal considerations over that person's position of subjectivity. So I just wanted to get some sense of your observations, or perhaps Fahad's observation, but above all, your observations of the promise and limitations of an administrative law lens within this regime of lawyering in such circumstances.
Well, the reason I left the parallel state and went back to the apartheid state is I think I can answer this question more easily within, oh, sorry, that's the pre-Civil War US, which I skipped over. So let me go to the apartheid state. But I can make the same point about pre-Civil War US. So I think it was telling in the way that you framed your question, that you started off with a really dire situation somewhere else, right? Somewhere in the Middle East or in some place between the wars, and suddenly you're back in Australia and talking about Australian administrative law. I meant to apologize to Nicole just before the talk, but I didn't get the opportunity because I realized that this talk is very much like the talk I gave to you in Auckland just a few years ago. But when I started this talk in New Zealand, it was just after Trump had been elected president. And I said to this audience, which included quite a number of New Zealand human rights lawyers, you should be really happy. You live in this kind of oasis of democracy and the rule of law. And then came the question period and they just berated me. What do you think? Do you really think that things are so wonderful in New Zealand? These are mostly people who are immigration refugee lawyers. What we deal with all the time is untrammeled official discretion, right? And I take that to be your point. And so we have in any operative system of law, as Scott calls it, even in the most decent societies, we have prerogative spaces, and immigration law is like that. I think often people in our penitentiaries live in a kind of prerogative space, and their lives seem to be controlled by unfettered or untrammeled discretion. But still, that all happens within the general legal framework. And I think that makes a difference. So let me give you an example from the history of apartheid security law, which I find interesting. So in the security statutes in the apartheid state, there were the most draconian privative clauses that you can imagine. They ousted the jurisdiction of the courts altogether. And just to add insult to injury, they would say you can't have access to a lawyer, you can't have access to independent medical opinion. You were stuck in a space which where it seemed you were completely at the mercy of the officials in the security apparatus. At one point during the states of emergency in the 1980s, police colonel somewhere in South Africa caused 2,000 people to be detained overnight. The lawyers went to court the next day and they said, well, Judge, look at the legislation. The legislation says that the police colonel has to be satisfied that this person is a threat to national security. Divide the number of hours in which these decisions were taken by 2,000. There weren't enough seconds for this police colonel to look at each detention. And the judge threw the matter out because most of the judges were appointed in order to do just that. But this was a really good legal argument, right? That if the judge had been faithful to any understanding of the rule of law, the judge would have said, yes, of course, this legislation is draconian. People seem at the complete mercy of the officials in the security apparatus, but actually this space is still within the legal framework. And this might seem like very little, but it does actually make a difference between being in a dual state and being in a rule of law state. And just one more thing from where you started with Hannah Arendt. There's a great book about Frankl by an American lawyer, a public defender called Douglas Morris, who actually spent time unearthing what one can find out about Frankel's legal victories. And one of Frankel's few legal victories between 1933 and 1938 occurs when he gets his client to plead guilty to a crime that the client has not committed in order to end up with just a short term in an ordinary prison, rather than be yanked out of the normative state into the prerogative state. So that's what his legal work amounted to. It wasn't the kind of legal work that I think these human rights lawyers were doing during apartheid when they contested these detention orders, or when human rights lawyers in this country or in New Zealand, however hard they find their work, are still going to court to contest what the state is doing to their clients. They still are doing that on a legal basis.
Cool.
Yeah, okay. Thanks so much for this paper, David. And I wanted to ask a question about how much depends on the fact that you're talking about human rights lawyers in thinking about kind of responding to the question of what one ought to do or what judges ought to do, against the background of this picture of the bond of reciprocity between legal subjects more generally and officials. And so I was thinking about imagining a debate with ANC detainees who refused legal representation and ANC detainees who accepted it. And kind of in debates about what was the right thing to do, what was the right choice to make. To what extent, if at all, does the answer differ, given that you're dealing with the subjects of oppression, those who fall into the second class space, as opposed to the human rights lawyers that you were recognizing that some human rights lawyers were also members of the second class space as well. But yeah, so to what extent, if at all, does the answer differ in thinking about what the correct thing to do is in that case?
I don't think there is an answer about what the correct thing to do is for these two groups of African National Congress detainees, those who wish to have legal representation because they're hoping for a less harsh sentence, and those who say, well, we just don't care, we're not going to participate because we don't want to participate in something that we regard as wholly illegitimate. So I have nothing to say to either of those groups about what they should do. What I do have to say is that for those who choose to participate, there is a basis for their participation. And that basis comes about because they are going to be working, or at least their lawyers will be working, within this general legal framework that bounds the state, no matter how oppressive or unjust it is. So if we go back to the debate that Wojciech mentioned between Wax and Dugard, one could argue that Wax was right, that judges staying on the bench served to legitimize the illegitimate in such a way that the benefits of staying on the bench were outweighed by the benefits of resignation. Sorry, the benefits of resignation would outweigh the benefits of staying on the bench, but still think that for those who stayed on the bench and the lawyers who appeared before them, the fact that there was legal order there meant that there was a moral basis for human rights lawyering to take place. And then one would have to weigh against the cost-benefit analysis on the first issue, the benefit of maintaining the rule of law so that the rule of law would have a chance of prevailing when regime change happened. So I don't think one can tell people what the right thing to do is when they choose as clients, or whether to be clients or not. That's a matter for them to decide. But if they do decide to participate, then what I want to draw attention to is that because there's legal order there, there will be a basis for their lawyers to work with.
Let's just squeeze in one more. Cole Kirkby.
Great. Thanks, David. My question is about maybe how we theorize about law. And so it seems here you have a kind of the rule of law state is kind of this, the ideal, and then there's kind of a perversion or an abnormal state, which is the dual state in its various forms on this continuum. And so when I look at your apartheid model of the dual state, it makes me think of what I find maybe the most persuasive kind of modeling of the apartheid state, which is Mahmoud Mamdani's work of the bifurcated state, and it's a state characterized. So his is a bit different than this. It's the apartheid state is rather kind of a one mode of the colonial African state, and he generalizes it beyond Africa, but he's in kind of his original work on that. And that's so it's the characteristic form is the Bantustans, the Bantustans where it would be characterized as decentralized despotism ruled by traditional authorities and customary law, basically where there was arbitrary rule through custom, a place where and as opposed to the civil space of citizens, you had this customary space of subjects, those where the rule of law didn't apply. And then so my question, I guess, is for him, the normal state, or the state we should start to theorize from, was from kind of like historicizing the state of where he was from, so Uganda, but looking at Africa more generally, post-colonial Africa, as a place where we start theorizing from, and we start thinking about the nature of law from that particular state, which was the normal state for the continent of Africa, and the rule of law state would be the exceptional kind of state from that. And I mean, we won't go into more detail, but he comes up with quite different kind of ideas of the value of civil society, which he does value, but in a different way, and the nature of how we should best kind of act and engage with those states. He's a fellow traveler with the National Liberation Movement in Uganda, so a different kind of thing. So I guess my question is, how should we theorize about the state? Should we theorize from this ideal model and kind of make exceptions for it in different situations, or should we theorize from this kind of place we're in, the moment we're in, and start our theorizing about law and the state from that place?
I think the answer to your question is, I agree with you that we should start in the state we're in and theorize from that space. But this is a bit like the debate we encountered today, and one often encounters at workshops, about the difference between ideal and non-ideal theory. So I'm a kind of non-ideal theory guy. I'd like to start off where I am, with some kind of fairly realistic account of the space in which I am. But in order to get a grip on that space, one needs some sense of how things could be different. And in the paper, as you'll probably know, I work with this idea of ideal types of state, which I get a bit from Max Weber. And the thought is that we have to sometimes abstract a bit in order to understand our situation. We have to develop a model, and then we bring it back to our situation. Maybe the model starts to fall apart, but we will have understood our situation better. And I'm not sure from my own reading of Mamdani whether he's doing anything really different. Now, in regard to South Africa, of course, the situation was a lot more complicated than it's depicted there. And if the ideology of apartheid could have been properly implemented, what one would have had was a set of parallel states, right? There would have been the areas where the whites lived, Then there would have been the Bantustans, or as they were later euphemistically called, homelands. And there was some attempt to develop these parallel states within the general framework. But that attempt never succeeded. Somehow the general legal framework bounded everything. So even within those Bantustans or homelands, often ruled by rather despotic sorts, it was still possible to appeal to the rule of law, to the courts, end up in the appellate division. It might have seemed rather an insecure route to getting the rule of law applied to, but it was still available to people. And it still marks a difference between that kind of state and the dual state. So I don't think South Africa ever became a dual state, even though within the Bantustans, people might have seemed to be ruled more by prerogative than by law.
David, between 1942 and 1972, Julius Stone gave many talks on national radio. His talks are being edited by his children, Jonathan, Eleanor, and Michael, and published by Sydney University Press. On behalf of Jonathan Stone, who unfortunately couldn't join us this evening, I'd like to present you with 2 volumes of the talks to thank you for delivering the address.
Thank you very much. Thank you. Thank you.
So before we finish, I would like to thank Ashley Joel and Bei Feng and Kimberly Hamilton for helping us out this evening. I'd like to thank all of you for joining us. And most importantly, however, I'd like to once again thank Professor Deisenhouse for his wonderful lecture. Thank you.